Welcome to Washington Legal Foundation and TechFreedom's webinar. My name is Glenn Lammi. I am the Executive Director and Vice President for Legal Studies at the Foundation. For those of you not familiar with the Foundation, we are in our 48th year of existence as an advocate for free enterprise principles, limited government, and the rule of law. In addition to doing programs such as this one, we publish papers, have a blog called the WF Legal Pulse, and the main thing that we do is file amicus briefs in all levels of courts, in state and federal court, regulatory comments, and various other legal-oriented litigation activities. The website is wlf.org. This is the 8th in its Tech in the Court series that we've been very proud to do with our friends at TechFreedom. TechFreedom is a nonprofit, nonpartisan technology think tank launched in 2011. The organization seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate human resource, human ingenuity. There's no real perfect way to do content moderation online. I think everyone who's joining us today is in agreement on that. As one of our speakers today has written, some people, including those of one ideological persuasion, want platforms to remove more content. Those of another persuasion want to remove less content. That creates quite a tension, certainly in the process. Legislatures that side with the must-carry crowd passed laws meant to advance their perspective a few years ago, laws that the U.S. Supreme Court essentially said were constitutionally problematic in Moody versus NetChoice. In reaction, federal and state regulators and law enforcement officials who believe that platforms are censoring certain content have begun test running new ideas, including addressing moderation as a competition issue. The Attorney General of Missouri has leaped headfirst into this morass with a proposed rule that forms the context of our discussion today. Our panelists will explain the substance of the rule, discuss possible legal and practical challenges that it implicates, and delve into the larger fit or misfit between competition enforcement and content moderation. Berin Szóka is the president of TechFreedom, named one of Washington, D.C.'s 500 most influential people by Washingtonian magazine. His work focuses on how law shapes digital media in the U.S. and Europe, especially freedom of expression, consumer and child protection in telecommunications. He was previously a senior fellow at the director for the Center for Internet Freedom at the Progress and Freedom Foundation. Daphne Keller directs the program on platform regulation at Stanford Law School's Cyber Policy Center and was formerly the director of the Intermediary Liability at the school's Center for Internet and Society. Her work focuses on platform regulation and internet users' rights. Until 2015, Daphne was Associate General Counsel for Google, where she had primary responsibility for the company's search products. Filling out our panel is Chris Marchese, who is Director of NetChoice's Litigation Center. He manages NetChoice's active lawsuits, amicus program, and legal advocacy. Before joining NetChoice in 2019, Chris worked at the U.S. Chamber Litigation Center and served as a law clerk for the Senate Judiciary Committee and for the Senate Permanent Subcommittee on Investigations. Just want to remind everyone we are recording this program. If you have questions for our speakers, we'll do a Q&A at the end. There's a Q&A tool in the toolbar for the Zoom webinar toolbar. If you have any questions, please use that to ask. And if you're by chance viewing this as a recording on YouTube, please like and subscribe our channel. So Chris, can you get us started off? What would this particular rule do?
Sure. So what the Missouri AG is trying to do is to get around the Supreme Court's decision in our case last summer. Moody versus NetChoice was all about content moderation and whether the First Amendment protects it. And the Supreme Court, in the majority opinion, says, yes, of course, the First Amendment protects editorial discretion. Editorial discretion includes content moderation. However, the AG here seems to believe that he can get around the First Amendment and get around the Moody decision by claiming that this is all about antitrust, right? That this is not anything to do with speech. It's all about sort of like market power and protecting consumers. And so what the AG has done is promulgate a rule that would apply only to politically disfavored websites, mostly, Facebook, Instagram, YouTube, and exempt politically favored websites like Truth, Social, Parler, Gab, etc. And so of those who are covered by this rule, they would have to allow users to have the option of using third-party content moderation tools. And, at a very high level, that doesn't sound like it's too big of a problem. But of course, it's the same thing that Florida and Texas tried to do and the Supreme Court shut down, which is to infringe on the editorial rights of websites. And so here, the AG is trying to get around that by using, his alleged antitrust authority, which of course that also is on very shaky grounds here. So, just at a high level, the rule creates a mandatory third-party content moderation regime. It applies to, I believe it's platforms that have 50 million active monthly users in the United States or 1 billion worldwide users. So again, it is very artificially crafted to apply only to select websites. And it's not genuinely about competition.
So why is the Missouri Attorney General proposing this rule? Kind of where does this fit in the constellation of government attempts to address content moderation?
I would I would believe that the AG is promulgating this rule because of the Supreme Court's decision in our case, right? The Supreme Court has clarified that, yes, of course, the First Amendment protects websites and it protects their editorial rights, which includes content moderation. And so here, the AG has that big problem, which is the First Amendment. He is latching on to some language in the opinion about a different Supreme Court case from the 90s that had to do with cable operators. And he's claiming that because the Supreme Court has said that antitrust laws are still on the books and that the government is still allowed to enforce them, that is a tool to get around the First Amendment. He's wrong. He's misreading the opinion. I'm sure we're going to get into that at length at various points today. But just at a high level, I think it's a tactic to try to get around the Supreme Court and get around the First Amendment.
So can platforms still do their own content moderation? Do they have to accommodate third-party platforms? How are they going to have to apply with this rule if it ever goes into effect?
That's a great question. I don't think that they can comply at all. It's literally impossible. I mean, if you think about it, it's what happens if you have two users and each of them have chosen a different content moderation journey? How does the platform sort of deal with that? What if one user chooses the platform's, sort of default editorial functions, and then a different user picks one that is completely at odds with that editorial regime? How do you display the content? How do you deal with that? And so from my perspective, there is no practical way of complying with it. But of course, if we want to sort of make things more abstract and conceptual, the First Amendment also says that they don't have to, right? You don't have to change your editorial regime to accommodate somebody else's. That has been clear going back a century in case law.
So Daphne, you've done some writing in this area, and on an amicus brief that you were counsel of record in the Moody versus NetChoice case, you've sort of advanced the idea of third-party content moderation in general, and as a sort of less restrictive alternative to state laws, such as those at issue in Moody. Can you talk first about third-party moderators as a general concept? How would you see that working?
Yeah, so this is an idea that's gotten more and more traction, kind of mostly in academia and among policy wonks in the past 5 years or so. One name for it is middleware, the idea that you would go onto a platform, go onto YouTube and choose as a user, I want the ranking provided by Disney, or I want content blocked on bases identified by my church, or, moving control back to the user over what content they want to see when they go online, but retaining the network effects of having one big platform where you can actually reach all of your friends and they can reach you, as long as they're sharing some content that fits the moderation rules that you've chosen. So what is appealing about this is mostly that it is less unconstitutional than most of the other proposals, right? We see all of these proposals, mostly from the left, that are about making platforms take down speech that's legal based on state disapproval. That has an obvious First Amendment problem. And then we see proposals more from the right, like the ones in Texas and Florida, that are about the state coming along and choosing some legal speech that the state likes and forcing platforms to carry that or prioritize that. That also has the obvious First Amendment problems that the majority identified in the Moody decision. So the middleware idea is, let's avoid having the state set speech rules for users at all, and instead move to giving users more options. Now, is that constitutionally perfect? No, right? For the points that Chris just made, it imposes on the platform's own right to set their own moderation rules. It doesn't impose as much as the Texas and Florida laws did, because the platforms can still set their own rules. It's just they have to also tolerate and provide a mechanism for users to make other choices. So there are real First Amendment questions to sort out there, and they maybe will get sorted out in litigation over this terribly drafted regulation out of Missouri. But the other set of First Amendment problems, which were not really at issue in the Moody ruling, are the First Amendment rights of internet users. And if you're focused on the internet users' rights to be free from unconstitutional state interference, middleware is actually significantly better than most of these other proposals. I want to read you a couple of Supreme Court quotes just because they're so beautifully on point. This is from the Playboy case, which is another one of those old cable cases. And it was talking about how if the state passes a law that imposes on people's ability to decide what legal content they want to see, they have to adopt the least restrictive means of doing so if they're trying to enforce a content-based law to restrict people's choices. The court said, quote, "Technology expands the capacity to choose, and it denies the potential of this revolution if we assume the government is best positioned to make those choices for us," unquote. Then it also said, quote, "If a less restrictive means is available for the government to achieve its goals, the government must use it," unquote. So there's sort of this soaring Supreme Court First Amendment language that really tracks the idea that the point here is to give individual people choices.
So do you think that there's a way for a competitive marketplace of third-party moderators to develop without the government mandate being involved?
I'd say there are three positions on this, and I fall in the middle. There are the people who think this can only happen if we pass a new competition law and force it, or a new communications law and force it. There are the people who think the market will provide, no legal action needs to be taken at all. I fall in the middle. I think there are laws we have right now that are preventing investors from funding middleware or innovators from building it because they're afraid their business will be shut down under laws like the Computer Fraud and Abuse Act, which is this very antiquated anti-hacking law. So I think there are things that both state and federal government could do to clear away unnecessary legal barriers to this coming along. But the fact of the matter is, those people who said the market will provide, and I was kind of skeptical about that, the market kind of seems to be providing, right? Like, we've just seen this incredible change in the social media landscape over the past 2 years, and a lot of people migrating to different services, of which by far the most important and relevant is Blue Sky. And people who've been on Blue Sky may or may not like the speech they're seeing there or the content moderation they're seeing, whatever. It is a relatively liberal discussion space right now. That's not the point. That's not what's important about Blue Sky. What's important about Blue Sky is it is being built from the ground up to be a technology that will enable this kind of third-party moderation, to make it really straightforward and easy to do it. And they're doing really interesting stuff with, like, users can generate their own labels for posts, and then other people can build filters using those labels. Just very smart and built from the ground up ways to make this idea possible. And they're doing it voluntarily, right? So maybe the market is providing.
Berin, what are your thoughts on this as a general concept, having a third-party moderator sort of marketplace in general?
Well, first, I love that line from the Playboy decision. That's kind of my mission statement for TechFreedom. I have quoted that so many times. It's the first time that someone's beaten me to the punch. So bravo, Daphne. It really is a great line. I mean, it's why TechFreedom is called TechFreedom. But as to your question, Glenn, look, I'm all in favor of user empowerment. I think Blue Sky is great. I use it myself. I wish Blue Sky were less of an ideological echo chamber. I'd love to have more interoperability. I think if there are market failings here, besides the one that Daphne has mentioned, which is really important and not one to lose sight of, the Computer Fraud and Abuse Act has been the basis for lawsuits that have been brought against tools that try to facilitate multi-homing, the idea that you could operate across multiple social networks, right? That's a real problem that Congress should deal with immediately. But I might go even farther than that. We could be having a different conversation about interoperability mandates to require these services to work together, that I'm not sure that I would entirely support that. I don't have a clear position on it, but at least it wouldn't directly go to the heart of the editorial judgments that are made by social media companies, as this new rule does. So, in other words, we could go at the problem a very different way of just making it easier for users to work across multiple services. That would be a kind of indirect way of getting it, facilitating competition. But instead, what this law tries to do is just to say, no, you cannot exercise editorial judgment over what's on your services. And I think it's really important to be clear up front, concretely, what we're talking about here. So what we're talking about here, you can see this most clearly at the list of exclusions in the rule, the things that you can still moderate. So you can still moderate sexually explicit content. You can still moderate content that directly incites criminal activity or consists of specific threats of violence against various groups. But think about how much that means that the platforms can't moderate anymore. They would not be able to moderate, for example, denial of the Holocaust, people calling in general for another Holocaust, the kinds of use of racial slurs that, for example, just recently led to genocide in Myanmar. I mean, these are not theoretical concerns. These are all things that these services would not be able to moderate going forward, which is why this is exactly like not just the Texas and Florida laws, but lawsuits that have attempted to compel these services to host the very worst, most despicable bigots in America, like Jared Taylor, America's leading white supremacist. That lawsuit was filed and led by Adam Kandub, who is now the general counsel of the FCC. This is the kind of thing we're talking about here, which leads us to the First Amendment. You could hardly have designed a law that was more obviously unconstitutional than this one. And I'll just walk you through, just quickly to set the stage here, what those constitutional infirmities are. They're things that you would learn, if not in your first day of First Amendment law, then certainly in your first week. You would know exactly how to avoid designing unconstitutional law, and yet this does every single one of those things. So it explicitly favors some speech against others. I just explained that, right? It says you have to leave some speech up. You can't take other speech down. It also favors some editorial judgments. You can make editorial judgments against those forms of user content. That itself is a form of speech on behalf of the platform. So it favors that kind of speech against other forms of speech that are effectively prohibited. It explicitly favors some speakers over others. So it sets limits. We've heard about them. If you have fewer than 50 million users in the US and fewer than 1 billion users worldwide, you're not covered by this rule. And it, of course, applies special rules that are not applied just to any other kind of internet service. And that's a real problem. And I'll unpack why that is in a moment. But just to mention the last thing here, and Chris has already gotten this in part, the implicit motive here is very obvious. The state of Missouri, the Attorney General, is doing precisely what the Supreme Court in Moody decried Texas for doing. In Moody, the court said, this is again 6-3, 3 conservatives, 3 liberals, quote, the reason Texas is regulating the content moderation policies of platforms is that these platforms is in order to change the speech that will be displayed on these platforms. Texas does not like the way these platforms are selecting and moderating content and wants them to create a different expressive product, communicating different values and different priorities, but under the First Amendment, that is not a preference that Texas may impose. Precisely the same is true here. And then that gets me to the last point, which is all of this rests on the Turner case. So Turner, in 1994, the Supreme Court upheld the Cable Act from 1992, its requirement that cable operators must carry a certain set of channels for broadcasters. The broadcasters wanted that carriage. The cable operators did not. The cable operators sued and they lost. Now that law discriminated against cable operators. It was not neutral, but it's really worth parsing what the court said there carefully. The court in Turner said, so long as these kind of requirements are not a subtle means of exercising a content preference, speaker distinctions of this nature are not presumed invalid under the First Amendment. And then it went on to explain what exactly was the special characteristic that justified applying a special rule onto to cable operators. And that was, in a nutshell, it was the idea that there was a physical connection between the cable operator and the television that gave the cable operator bottleneck or gatekeeper control, and that allowed the cable operator, unlike speakers and other media, to silence the voice of competing speakers with the mere flick of a switch. Now, Texas and Florida and Missouri here, they all try to make this sound like that case, but it's nothing like that case. Social media services don't have a physical wire that they control. It's not the only cable that goes to your home, and it certainly wasn't given to them as a government franchise that gave them a monopoly by the government, which is one of the factors that Turner noted. In other words, there was state action in Turner that gave these cable operators their monopoly control. No, it's just that these services are relatively popular and people prefer to post there, and it's somewhat harder for them to go post somewhere else. That's not good enough. That's not the unique gatekeeper bottleneck control that justified having a special rule for cable operators in Turner. So this is all just an elaborate ruse. It's the same warmed over bad legal arguments that were made in the Florida and Texas cases. And the only difference here is now the Attorney General of Missouri can try to hang his hat on this one line in Moody where the court acknowledged that, of course, states can always enforce competition laws. But we already knew that. I mean, the Supreme Court has said since 1945 in the Associated Press case, of course, the media companies are not immune from competition laws. But when they've said that, and this is what the Moody court meant when it referenced the competition laws, what it meant was that, of course, the states and the federal government can enforce laws of general applicability. They can bring a lawsuit if you are shown to monopolize a market. That's not the same thing as writing a special piece of legislation and calling it a competition law. And this one is not, by the way, I'll explain that, but this does not actually rest on competition law. They're trying to dress it up as such. But these are just very different things, and there is 0.000 chance that this will survive in court.
Let me read that specific passage from the proposed rule, just so everybody knows. So it says, last year, the Supreme Court made clear that it is critically important to have a well-functioning sphere of expression in which citizens have access to information from many sources because, quote, that is the whole project of the First Amendment. That's from Moody versus NetChoice. It further made clear that local governments can protect that access by enforcing competition laws. Having considered this new legal authority and the available evidence, the Attorney General has determined that a rulemaking is necessary to clarify how Missouri's competition laws protect the project of the First Amendment in the context of social media. Daphne, what are your thoughts on that before Berin tears that apart?
Oh, it's garbage word salad. Like it is a ridiculous reading of Moody. Like the point of the discussion in Moody about public discourse is the government can't come along and set new rules for it. That's why the Texas law is unconstitutional. That's why this proposed Missouri regulation is also unconstitutional. And then the passage in Moody, it talks about competition twice, once in the main text, once in the footnote. And I agree with Berin's take on that. I think part of the reason it's in there is that there were a number of, I think, kind of alarmist briefs that went into the court saying, oh, if you side with the platforms here, you're ruling that the First Amendment precludes basic competition and consumer protection law, which I think was not the case ever. But this is the Supreme Court saying, look, you guys, we are not ruling anything about competition. Obviously, antitrust laws can still be enforced. And that's, as Berin says, it's unsurprising. What they did not mean is that states can pass a new state-backed regulation of speech that sets new rules for speech and slap the word competition on it, and that makes it constitutional.
Berin, want to add? Would you like to add before I ask Chris about it?
Yeah, well done. Well said, Daphne. It's worth remembering that Moody was a preliminary ruling, right? The court didn't get to the merits of all these issues. The court actually sent the case back down to the lower courts. And everything that we're quoting from is a sort of extended aside telling the Fifth Circuit why its approach was so deeply flawed. So the court was being less precise about this than they really should have been. What they really should have said was something like, of course, you can continue to enforce laws of general applicability, and that would include not just competition, but consumer protection. I mean, just for example, we'll maybe touch upon this at the end, but in consumer protection, if let's just say if you made as a platform a very explicit promise about something, you said, for example, all of our decisions about this particular kind of content moderation are made by humans and not AI. Just suppose that was the case, and then it turned out that you didn't do that. I think that would still be subject to a deception claim, right? That's a business practice, and business practices. That's what the Supreme Court referenced in the Associated Press case from 1945. The business practice of the Associated Press to let its member newspapers veto the entry of a new newspaper into the pool because that new newspaper would compete with it. That's regulable by the antitrust laws. That's all the court meant here. And the Missouri Attorney General is just making much out of nothing.
Chris, I have to imagine that your NetChoice and colleagues, and you never imagined that the positive decision that you got in Moody would be an inspiration for this kind of attempt to end run First Amendment using antitrust. What were your thoughts on that?
As a general matter, we always expect that government actors, whether they're federal or state, are going to abide by a Supreme Court decision or any court decision for that matter. So it is definitely disappointing to sort of see this attempt to do an end run around the First Amendment, to do an end run around the Moody decision. But ultimately, one of the nice things about sort of having these cases come up in a constitutional context is like, states, whether it's lawmakers or the AG, are always going to sort of try to push their powers, right? There's a reason why we keep having First Amendment cases go through the court system, decade after decade. It's because the government doesn't always learn its lessons. And so what's nice about sort of having the Moody decision on the books and future decisions is that they are at least a temporary sort of, or I shouldn't say temporary, they are a mechanism to hold the government accountable in the time. And then they also serve as a roadmap for future litigants to hold the government accountable. It's an ongoing project. So I guess as a general matter, we're disappointed that, less than a year out from the Supreme Court's decision, we're seeing sort of this creative attempt to disobey the court and the First Amendment. But of course, that is sort of par for the course with government actors as a general matter.
So let's circle back
for the courts.
I'm sorry, go ahead, Berin.
Par for the courts, as it were.
Okay, that's very good. So let's circle back for a second to another issue in terms of what the legal basis is for the Attorney General's actions here. He's sort of couching this in the state little FTC Act. Berin, what's the anti-competitive conduct here? I mean, what's the supposed consumer harm that's here?
Yeah. So he makes a very specific claim about that. He says that the specific anti-competitive practice here is, I'm looking for the exact quote, this proposed rule will clarify that dominant social media companies cannot acquire or exercise monopoly control over content moderation on the social media platforms they create. And this presents a risk of substantial injury to consumers. So one thing to note here, part of the reason that this is being dressed up as a competition claim is because, again, the Supreme Court's always said competition laws are generally applicable. The Supreme Court said that again in Moody, and it becomes a way of trying to justify that they're only applying this rule to dominant platforms, right? This is really essential. This will sound like a small thing, but much of Supreme Court jurisprudence in this area turns on these questions of is the law or rule neutral as to content primarily, but then also is it neutral as to speaker? Because that speaker preference, again, that can be a subtle means of exercising a preference here. And I just want to note some little background here that might be helpful. In 1936, there was a case called Grosjean, where Huey Long, who was running the state of Louisiana as a fascist dictatorship, passed a law that imposed 2% tax on newspapers. And he imposed it only on newspapers that had circulation larger than 20,000 per week, which happened to be all the newspapers that criticized him, right? That was the beginning of the Supreme Court having to recognize that these sorts of facially neutral laws as to content can have this subtle preference because of the way they're structured. And then in Minneapolis Star, in 1983, Justice O'Connor really dealt with this issue very well, and she noted that because that law applied only to newspapers, it taxed their ink and paper, and it applied to only newspapers that used more than $100,000 worth of those per year. That applied only to 11 publishers and to the Minneapolis Star in particular. And even though there was no evidence of intent, she says the power to tax differentially, as opposed to a power to tax generally, gives the government a powerful weapon against the taxpayer selected. It's exactly the same point about competition law. The reason that competition law in general, the Sherman Act, is not a problem is because it applies to everyone. And the doctrine that's made about it applies to everyone, and it's enforced case by case. So, a thing I want to point out here that maybe will elude a lot of attention is what law they're relying upon here. You say they're relying on the baby FTC Act. Well, we think about the FTC Act, and the FTC Act, we know the FTC does both consumer protection and competition. But what's worth noting here is they're relying specifically on a merchandise practice act. In other words, a consumer protection act that governs it. Yes, it governs unfair practices, but those unfair practices are about consumers making purchases. And he says, Attorney General Bailey, that he can use this law to bring a competition claim because there's one court case that says that this law is to be interpreted very broadly. But I've looked into this. I'm going to file comments on this. I'll lay this out for you. The courts have said that there's never been a competition claim brought based on this law. When Missouri brings competition claims, it always brings them under the Clayton Act, which specifically authorizes states to sue, or under a separate Missouri law that governs competition. And the reason here is really important. It's because he's trying to dress up as a competition law what's actually not. It's, this broad language about unfairness. And he's trying to read that very broadly to do precisely what conservatives have been warning about at the level of the Federal Trade Commission since the mid-1970s, right? The FTC's unfairness authority was constrained to avoid exactly the kind of thing that he is now trying to do, which is having the Attorney General or the FTC at the federal level make what are essentially legislative decisions because of the inherently broad and elastic concept of unfairness. So a little more context here for the misrepresentation of both the First Amendment and indeed Missouri law as well.
Chris, one of the criticisms of state laws, such as those that NetChoice has been challenging in courts, is that they'll backfire, reducing online speech options. Do you see that as an outcome of this particular rule if this does come into effect?
Absolutely. I mean, even assuming that there was a practical way of actually sort of having this choose your own content moderation journey for every user on the internet, the fact is this is going to reduce overall speech. And what I mean by that is if you think about it today, content moderation sometimes gets a bad rap, but it's also preventing us from being inundated with bots, spam, and other garbage content that we just don't want to see, right? And so if you log on to, let's just say Facebook, and suddenly it is flooded not just with spammy or commercial speech that you don't want to see, but also racist speech, hateful speech. And then to top it all off, there's also bots and trolls and so forth. And that is all sort of geared up because of the content moderation journey you've chosen. Well, you might have enough, self-awareness to say, let me choose a different journey, or you might just leave the website. But regardless, the collective impact of all of these decisions is to reduce the overall speech of everyday Americans and to promote and elevate speech of those who are using the internet to share, vile content or just to be a jerk. And so, whether it's Florida and Texas or here, this AG rule, the fact is, like, these efforts to quote unquote protect the First Amendment really just violate the First Amendment and reduce overall speech, right? I mean, if the government really wants to protect the First Amendment, it should stop violating the First Amendment.
But Daphne, circling back to one of my earlier questions for you, I had noted that in the Moody case, you had authored a amicus brief that talked about how third-party moderation can be a less restrictive alternative to must carry or must prohibit laws like those in Texas and Florida. It sounds like you don't think that the Missouri approach is really the way to do it. Can it be done in a way that it is a less restrictive alternative to more direct violations of the First Amendment?
So I certainly think it can be done in a way that's less restrictive as to the rights of internet users. This still leaves these questions Chris was talking about how we think about the platform's rights in that situation. But if we look at the cases where the Supreme Court has upheld carriage mandates, like Turner, as Berin was talking about, they tend to be the product of really careful technocratic planning. Right. So the law at issue in Turner had all these congressional hearings and all of this evidence, and then it had gone to the FCC for, detailed regulatory implementation, and gone to the district court in that case. As I recall, there were thousands of pages of evidence submitted there. There was just this whole process to arrive at, where wonks and nerds sat down and wrote fine-grained rules that fit the technology at the time. This law is the opposite of that, right? Like, you're not going to arrive at, unfortunately, you're not going to govern evolving technology without some kind of technocratic process like that and get rules that quite work. So there's a lot in here, including the discussion of user privacy, that's just does not make sense. And it kind of has this vibe like somebody who's only ever been a passenger on an airplane set down to write the FAA regulations for engine safety or landing gear. Like, we need that degree of involvement by nerds to arrive at laws that actually achieve their intended purpose.
Daphne, well said. And to me, the clearest example of that is this provision that is exactly what Texas argued. So it says, nothing shall prohibit a social media platform from moderating blah, 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 content that in the company's good faith judgment, the platform is specifically authorized to restrict or moderate by federal law. So HB 20, the Texas law, had exactly the same provision. And this came up in the litigation. And what Texas said, not having really explained this, was, oh, that's a reference to Section 230. And it means that we're not going to stop the platforms from moderating content that is enumerated in 230 C2A. So C2A has a list of things. So spam, for example, would fall into that. The Trump administration in 2020 proposed a rule to interpret what those things mean. That's been, I think, the clearest statement of what that narrow conception of what 230 should protect would cover. And so it covers a lot of things that you would be concerned about. There are two problems with this argument. Number one, and to Daphne's point about how just embarrassingly amateur all of this is, it's obvious that 230 doesn't authorize anything. It's an immunity statute. It just says you can't be sued for the content that you moderate that falls into these categories. So even the wording doesn't make any sense. But then you just set that aside. You just assume that's what they're trying to do. And you set aside my earlier point that this is content-based discrimination and therefore makes this whole thing unconstitutional. You just set all that aside. Then we get to the point of like, but what does this actually do? What precisely would this change about the online experience? And I would submit that the state attorney general may not really know what this would do. Maybe they do. But it's actually pretty easy to see. It means, again, you set the bar at incitement to violence. Yeah, maybe that's something you can continue to moderate. Sex stuff, but hate speech generally, all the examples I gave you earlier, nope, you cannot moderate it. And I think people on the political right, that might sound good to them when it's Trump being moderated or fact-checked. But if you actually care about anti-Semitism, You have to understand here that what this would do is allow the worst anti-Semites in the world to, on major social media sites, to discuss their plans for another Holocaust. I mean, that's the reality of what we're talking about here. And look, at the end of the day, if you want to go off and do that on your own private site, that's what the First Amendment protects. You have a right to create that space for your vile speech, but you cannot compel large services to host that speech because they will be held responsible for it. I mean, the Supreme Court said in Mooney that that's not that the risk of association is not itself a necessary prerequisite for a First Amendment suit, but it's certainly the case. Another distinction from Turner. Nobody in Turner thought that the must-carry mandate was going to force the cable companies to disclaim association from the speech that appeared on their platforms, because it was, the most carefully filtered speech in America. It was the stuff that showed up on broadcast television, right? Of course, they didn't object to that content. So this case is completely different. Social media services clearly object to that content. They've always objected to that content. They would have to go out of their way to disclaim their association with that content. In other words, you'd be compelling them to speak. These are all the distinctions that the court drew in Turner to uphold that must-carry mandate. And they're all reasons why this one would never survive.
If I could follow on that, since Berin was talking about the provisions in the Missouri regulation where it says, well, platforms can moderate the following things that we disapprove of, and it lists out some examples, including, I think, sexual content. Some of the things it lists there as the state disapproved speech that platforms can moderate are, as far as I can tell, verbatim lifted from the Texas law, which means that they have two problems. First, they're really badly drafted. So one of them, for example, says, if there's a group that has a purpose of protecting victims of sexual abuse, then anything they report can be taken down. So if I'm a platform under this law, the first thing I do is set up my AstroTurf group that has that purpose and reports the things I want to take down. That's a joke. No platform lawyer would do that. But more importantly, because this was litigated to the Supreme Court just a year ago, there is a stack of briefs from First Amendment luminaries sitting there explaining why these things are unconstitutional. So it's just, again, the bad drafting both makes it a bad law and also just makes it this really sad, inefficient waste of time for all of the smart people who are wasting time talking about this.
So in a great piece that you did for the University of Chicago, Daphne, you wrote about some of these state approaches to online content regulation as is the stuff of dormant Commerce Clause nightmares. I imagine you have the same concern with what General Bailey has proposed, in addition to everything else that's wrong with it.
Yes. And I just, people should imagine a 50-state fragmentation of different speech rules across state lines. It's not just the difficulty of administering that for the platforms, which is quite significant because particularly for state lines and mobile signal, it's actually geotargeting gets complicated. But more importantly, for users, if you're a business user and you're using Instagram to reach customers and you have no idea if you are reaching them in all of these other states, that's a problem. If you're a political organizer, if you're a person talking with their family, like it's bonkers to have 50 different state rules governing that. Now, as to how an actual dormant Commerce Clause challenge would play out, there was a case about pork a couple of years ago that made this more complicated, but the practical problem and the stupidity of doing it this way is quite overwhelming. One of my former Stanford colleagues, Tyler Velasca, wrote an article actually identifying a strain in First Amendment case law that imports this sort of uniformity issue or the problems of non-uniformity as a First Amendment problem. I think one of the I can't remember the name of the organization, the group in Utah, incorporated that in their Moody brief. So there are other ways of getting at this problem potentially, but I don't think anyone could deny that it's a problem.
Chris, how much government oversight is going to be required to enforce a rule like this?
A massive amount, right? I mean, I don't have a clear sense of, just how hands-on the AG's office will be, but what we can guarantee is that, an AG's office that feels comfortable promulgating this type of rule, despite very clear evidence that it's unconstitutional, is likely an office that is trying to bend the law for political purposes. And so, it might be that they don't actually really enforce the law day to day. They just sort of wait until they are mad at a website and then decide, okay, let's go in search of a violation. But regardless, like, to actually be in compliance with this law, I mean, if you have third party content moderators that you have to sort of allow onto your website, and you have to allow these operators to sort of like um, you have to prefer their editorial judgments over your own. Like, that's a lot of data too, right? We've sort of mentioned the user data problem here, but like, compliance here also poses yet another risk to user data, right? To know whether you're sort of like operating correctly with these third party content moderators, you need data on how those moderators are moderating. And so it just becomes like this collection of privacy violations and speech violations. Daphne, I don't know if you have a more technical answer than my, sort of glib response there, but I don't foresee how this could work in any type of real world setting, which also gives me concern that the AG would be even more creative than this rule already sort of allows him to be.
Yeah, well, I'll speak to the real world setting piece. I mean, I do think this is part of why I emphasized Blue Sky at the beginning. Like, Blue Sky is being built from the foundations to be able to have this sort of composable moderation, they called it, and to let users make these choices. The technical challenges to bringing in third-party moderators on top of the pre-existing infrastructure of a YouTube or a Facebook, I think are quite significant. This is why when I first wrote about this, I called it magic APIs, because the technical connection between the machines you'd have to have would be magic to make this work. That said, there are technologists out there who say this can work. Like, there's a list of issues with middleware proposals that are technology problems. And so, like, lawyers can't solve them, but maybe engineers can. That's one of them. Another big one, and I think this is a major impediment that's widely misunderstood, has to do with user privacy. So imagine that I am a Facebook or Instagram user, and I'll make it Facebook. I have friends and family members who share content privately just to a list of people they know. So my cousin announces her pregnancy to her 500 friends on Facebook or whatever. If I want a middleware provider to come along and do content moderation on my feed and rank it differently, that middleware provider needs to see my cousin's post about an important life event and health condition, and they don't have her consent to do it. That's basically exactly the scenario that brought us Cambridge Analytica, was one user giving a sketchy third-party vendor data about their friends. Again, I think there are technologists who think you can solve that problem, that you can preserve the cousin's privacy in that scenario, but it's a big thorny question that's completely unanticipated in this regulation, as far as I can tell.
Berin,
But I would just reiterate that goes at the problem from the opposite direction of making sure that the users can post and interact across services. That, again, I think that's potentially viable from a First Amendment perspective. That's the opposite of saying that the platforms cannot moderate on their own services as they see fit. I just want to note as we wrap up here that this point about the potential for opening the door to future abuse is precisely what Justice O'Connor got at in the Minneapolis Star case, where she said, citing the concerns of the Anti-Federalists, she said their fears were well-founded. And she goes on to say the very selection of the press for special treatment threatens the press not only with the current differential treatment, that is favoring one speaker over another, but also with the possibility of subsequent differentially more burdensome treatment. Thus, even without actually imposing an extra burden on the press, the government might be able to achieve sensorial effects, that is, reshape the nature of speech in the marketplace. For the threat of sanctions may deter the exercise of First Amendment rights, here exercising editorial judgment, almost as potently as the actual application of sanctions. In other words, this isn't just some sort of soft policy argument. This is exactly why the Supreme Court has consistently rejected these kinds of speaker-based discriminations, with the very outstanding exception of the one and only physical pipe that connected the cable operator to the TV in your home back in the early 1990s. That is not the world we live in anymore. You can always move on to other services. It's not perfect. We can make it better. It's just not the same thing as that gatekeeper bottleneck control that justified must carry when the cable operators didn't object to the content they were being asked to carry.
A reminder our viewers that we're happy to take your questions if you have any. I'd be loath to finish this up without at least referencing what's going on at the Federal Trade Commission. Montana, that the Missouri Attorney General is not the only one who's trying to convert content moderation into a competition issue. Chris, what's going on with the FTC? What are they asking for?
Well, the FTC seems to have forgotten its long-held tradition of not translating exercises of First Amendment rights into something that the government can investigate and regulate. But about 20 years ago, the FTC declined to investigate Fox News over its slogan, fair and balanced news, right? Like some liberal group said, obviously, Fox News is neither fair nor balanced. You must investigate. The FTC said, no, that is an editorial judgment. We cannot, sort of infringe that. There's no objective way to sort of discern whether Fox News is actually fair and balanced. But regardless, it's just not a thing that the government, let alone the FTC, can get involved in. Here, 20 years later, things have changed. The FTC believes that it has a mandate to police online speech and content moderation of that speech. And so it has been asking for any type of anecdotal evidence of platforms not abiding by their own, content moderation rules, or harms that people suffered after they had their accounts removed or their content removed. It's really a fishing expedition to sort of drum up any type of evidence from everyday Americans that, they're having a rough go online, and then using that as sort of a basis for further investigations and so forth. It's jawboning, right? At its core, this is just jawboning. It's the FTC using its investigatory powers to try to scare, online publishers into changing their content moderation to match what the FTC chairman and his allies believe should be the right approach to online speech. I don't think that there's anything really genuine in the RFI. It all comes down to just basically, if you have a complaint about tech, let us know.
So the FTC itself had to do moderation of its comments, right? Sorry,
yeah,
go ahead,
it was
Daphne.
amazing. They will develop on what you're saying. People were uploading comments saying, "I can't believe I was silenced when I said blah blah blah," and people at the FTC were like, "Oh, we can't host something that says blah blah blah. That's really offensive." And so they failed to host, in their capacity as a platform hosting user-generated content. They declined to host the exact same user-generated content that the platforms had. But the thing I was going to add on is, just maybe half an hour before we started recording, there was a news item in the New York Times about the FTC also threatening to hold up a merger of advertising firms, basically to force them to advertise on X. Saying a condition of the merger should be that they couldn't take into account political considerations in deciding where to advertise, which is both a truly wild use of FTC authority in a way that profoundly affects speech, but also, part of a major factor here has always been that if a platform carries a bunch of content that offends lots of people, or it has tons of spam or scams, whatever, they get punished in the market by advertisers, because advertisers don't want their ads placed there. So this is putting a thumb on the scales to get rid of that major component of how the real world marketplace of ideas works.
Sorry, Berin, I didn't mean to cut you off there. Go ahead.
Yeah, all in the name of free markets. I mean, it's pretty rich coming from a chair who wraps himself in the mantle of Adam Smith. But, I just want to close here just to note that, again, these companies are not immune from the antitrust and competition and consumer protection laws. The critical point is it's their business practices that can be regulated, not their editorial judgments. So I don't think there's nothing the FTC can do here. I gave you an example about something I think that might be actionable. I understand that having taken comments that the commission is now unhappy with the comments they received because they didn't get what the lawyers inside the agency understand would be necessary to bring a case. They didn't get, specific, you said X, but you did Y. And we can objectively tell the difference between those things without having to make reference to underlying judgments about content, right? That's essentially the way you would look at how you bring a case. So it's not a binary, right? I mean, there's, potentially there are cases they could bring. I think what's actually going to happen is they will bring investigations, endless investigations that will be used to, as Chris said, to jawbone, to pressure tech companies into changing their content moderation practices, even more than they already have. I mean, Meta and now YouTube have both gone out of their way to allow speech on their platforms that they previously did not, for very obvious political reasons, because they have a lot to lose. And I'll just note here in the end that in some ways, we may have some people watching who don't care about content moderation. They don't care about the tech companies at all. But what they should care about is this is the clearest example that I have yet seen, certainly on the state level, but maybe even more generally, of conservatives in their desperation to try to stick it to big tech companies, embracing the banana far left ideas that they've been against literally for decades. And that here, again, this seems like a small detail, but this entire thing rests on the idea that the attorney general can bring a competition suit or can make competition rules based on the unfair practices language of the consumer protection statute, which is never done before, right? He's just untethered competition law in Missouri from the antitrust laws, because there's clear state court and federal court language saying that the antitrust law enforcement by the state of Missouri is tied to the federal law. So he just suddenly severed that. Now, what that means is you could see exactly that same logic being used by state attorneys general that you don't like. They could bring suits, alleging unfair trade practices for any sort of bullshit theory that is invented by any state AG, and it would be no different from what Lina Khan was trying to do to make legislative rules in the name of dealing with unfair trade practices to reshape every workplace in America, to ban non-compete agreements. It's that just done by Republicans.
So we could spend an entire program on what's going on at the FTC, and in fact, TechFreedom's podcast did that. So I definitely would encourage you to check that out.
And our day-long webinar on that
That's
topic.
right. And your day-long webinar with CEI. That's right. I'm sorry I didn't put a plug in for that as well. We do have one question that I will ask because we still have a few minutes. How does the Missouri approach compare with FCC consideration of a declaratory rule regarding Section 230? It's not aimed at any one particular speaker, so whoever would like to take it on, go right ahead.
Very similar. I mean, I've already noted, one of the key aspects here is that this makes reference to 230. So to the extent that the FCC narrows how 230, specifically 230C2A, how that applies, it narrows the exception here. In other words, the kind of content moderation that you would be allowed to engage in under this law would be narrowed by that interpretation. So the two things actually fit together in an interlocking way. But more generally, the underlying rationales are precisely the same, right? It's the same idea that these services have gatekeeper power. They're reshaping the competition landscape. They can control speech, blah, blah, blah. And I would just note that in Moody, the court said this. It said, referring to its 1974 decision in Miami Herald versus Tornillo, which refused to allow newspapers to be subjected to must-carry mandates. The Moody court said, The Tornillo Court, 1974, devoted 6 pages of its opinion to recounting a critique of the then current media environment, in particular, the disproportionate influence of a few speakers, similar to the ones heard today. It made no difference. However imperfect the private marketplace of ideas, here was a worse proposal, the government itself deciding when speech was imbalanced, then coercing speakers to provide more of some views or less of others. That was true of the Texas and Florida laws. It's true of the Missouri law. It's precisely what the FCC's attempt to reinterpret Section 230 would do.
If I could just throw out one last thing too, this,
Sure.
as Berin was talking, it occurred to me, this also eliminates competition, right? Like content moderation is part and parcel of the overall service that various websites provide users. And so if you require, interoperability of like the biggest, most popular websites, and then you sort of you're cutting out something that they do compete on as part of their larger service or product offering, right? So if you make everything the same, you're actually eliminating competition. You're discouraging innovation. You're discouraging, like Meta just walked back its fact-checking program a few months ago. You're discouraging actually, you're doing more than discouraging it. You're prohibiting it. And so, that's another, I guess, it's more than just ironic. It is a casualty of this type of thinking.
Well said, Chris. Thank you very much. Well, thank you, Berin, Daphne, and Chris for joining us today. And thank you everyone online that was with us today. As I had noted at the outset, we are recording this. So if anyone came in late or knows anyone that might want to watch it, it'll be available on our YouTube page later this afternoon. There's a very short survey that will launch when you close out your window here. If you take 2 seconds to do that, really appreciate it. And again, thank you everyone for joining us today.